Coming up on this program, we show you how to get connected. Find out how to choose an internet service provider. Discover the newest form of communication, electronic mail.
Ways down and ready to ride. One by one, billion by billion, they're holding up half the sky. Raise your hand if you're ready and willing, if you know it's time. Time for a girl on time. Time for a girl on time. Time for a
I'm not quite as quick with my click. Sorry. I hope everybody's doing well today. Thank you for being here. Happy Sunday. Today is Sunday, October 13th, and in Canada, this is Thanksgiving weekend. Why isn't the chat coming up? Oh, just nobody's saying anything. Okay. Whatever. We'll just sit here in silence. Hi, Vicky. Thank you for breaking the silence. That was awkward for a minute. I hope everybody's doing well. Like I said, today is Sunday. Kimby's here. Woo! Oh, look, you guys. I got my thing I ordered on Amazon for my Fitbit so that I don't get any rash, hopefully. Thank you guys. So Canadian Thanksgiving is very similar to American Thanksgiving, except it happens a month earlier. And I've always been told that coincides with the later harvesting time, or earlier harvesting time, I suppose. No, later? Earlier. Whatever. I believe that it is just to space out holidays, because in November we celebrate, or we acknowledge, Remembrance Day, which is a holiday, and on the 11th of November, and I think that you guys do that on a different day in May, if I'm not mistaken, which is when we do Victoria Day after Queen Victoria. But you don't seem to have like a real holiday in October, do you? Oh, Columbus Day. That's coming up? Okay. Anyways, so when you're in school and when you're working, especially if you work for the government or you have a union job, you get a long weekend. Long weekends mean less to me now than they used to. Veterans Day, yeah. Well, ours is Remembrance Day for the war, I guess. But, anyways, the whole point is that I think they spread out the holidays. But we just had a new holiday that was National Truth and Reconciliation Day. Was in September 30th, also known as Orange Shirt Day, but that has become a federal holiday. Around here, Halloween is not an official holiday, though it is widely observed. I will say that. My former neighbor used to run what I would call a spooky house. Okay. In fact, I made a video of it. Oh. Could I find that video? Probably. It's posted to my long deceased TikTok. I think I'm just too old for TikTok. But anyways, it's on there. It was a couple years ago that I took the video. But he would go all out. He would decorate, but then not only that, he would have him and his children and friends stationed in spots to be scaring people. And he would have like a smoke machine going and lights and fucking everything. And I lived across the street for 20 plus years. And so, first of all, this is the neighbor I've talked about before that was always outside, that I knew if my daughter ever ran outside, he would talk to and stop because he would be outside working on something. And so we know about this haunted house coming. It's not a haunted house though. You don't go into the house. It's just like to the door, get your candy and leave. And but it became very popular, and you could see why. I'll try and find the video and you'd see it. But anyways, and these children were like running and screaming in just terror. But he would always set aside some time for my daughter to come through and not be scared. He would call all the people off, and he would be like, just let her trick or treat nicely, which was really sweet of him, because they terrified most children. And I just, they got a lot of glory and glee from it, I'll say that. They had like chainsaw sounds. Oh, that's scary for kids. Anyways, I'll try and find that video. But, I enjoy Halloween. My mom doesn't. She never did. She wanted it, like, you know, the candy was just a whole problem in itself. And then just the whole thing. Halloween's just a problem to her. I was always like quite, I don't know, giving to my daughter for what she wanted to be for Halloween. But, you know, she's sort of outgrown it now, being 16 almost. So as long as she doesn't go and cause mayhem, then we're happy with Halloween here. But anyways, Thanksgiving comes before Halloween usually. And, how could candy be a problem? Well, when I was a kid, I mean, I don't know. I don't want to self-diagnose, but we'll just say I wasn't diagnosed with ADHD as a kid until I was an adult. And so a lot of my behavior makes a lot of sense, but like I would easily like freak out when my mom would take the candy from me eventually. I was actually the type of person that I let my daughter binge on Halloween. It's a once a year thing. I implemented a policy early, so she, on Halloween night, a full binge. Whatever she wanted. However much she wanted. I did not care. And then the next day, the candy was gone, but it was replaced with new books from the, I don't know what I called it, Halloween fairy or something like that. I was like, if there can be a fucking tooth fairy, there can be a Halloween fairy. And you know what the funny thing is? My daughter is 1,000 times easier than I ever was as a child. And so I found myself implementing all these tactics that I thought might work with me, but that were really not necessary for her. She's not a greedy guts. I don't know how else to put it. Like she was never one to like hoard candy or whatever. She can have a little bit and that's fine. And so I've always just kept nice sweets in the house. Now we try and eat healthier, you know, like not healthy, but just like less guilt about eating is what I try and go for. Anyways, I've been talking for 9 minutes. I'm drinking coffee. What are you guys drinking today? We have Court to watch because I did download it. That's why I was late. I had to download it onto one computer. Why the laptop that sucks at streaming is still a little workhorse when it comes to downloading? Tell me that. Tell me that. Tell me why it works when the new computer doesn't. I don't get it. It's like that ex-boyfriend or girlfriend in your life who like just sticks around and like, you know, makes themselves somewhat useful at a very specific task, and you realize, well, fuck, if I get rid of you, I'm gonna have to figure out how to do that specific task perfectly somewhere else. And you sort of like, ugh. Lavazza. Classico. Is that the one that comes in the free, like the really like sucked in package? I drink coffee provided to me by Christopher Angleby from my Amazon wish list. I drink Tim Hortons coffee, and it is delicious. Okay, forgot to turn that off. Thank you though. That's a free one. That's free for everybody. We didn't talk about this. So here we have Maya Moore and Dylan Luke. Dylan has, it looks like 2 L's in his name. That's a red flag. And then Maya is spelt weird, also red flag. Dylan is at his grandmother's or his mother's house based upon the somewhat like weird presentation of family photos above him. Like just straight line across. Right up against each other. No space. Again, this upward angle that my new computer has much more RAM. It's not about that, Martha. It's literally, well, part of it is I have one program on my laptop that I don't want to put on my new computer. So
The 37th Circuit Court is now in session with the Honorable Brian K. Kirkham presiding, calling case 2023-2456 DC, Dylan Luke versus Mia Moore. Today is Monday, September 30th, 2024 at 9:59 a.m.
Court will note the appearance of Mr. Snyder on behalf of the plaintiff.
Defending, Your Honor.
Good morning.
Good
This
morning.
matter is before the court on the plaintiff's motion to enforce and amend the final consent order for custody, parenting time, and support. Mr.
Your Honor,
Snyder.
this is defendant's motion. I represent defendant Maya Moore.
Oh, okay. I'm sorry. Had down that it was plaintiff's motion on our notes.
That's okay.
You can go ahead and proceed, Mr. Snyder.
Yeah, so this is our motion. The court ordered a consent order earlier this year for the party's minor child. It said mother gets custody Saturday noon to Wednesday noon. It did not have a place to meet for the parties. They live a while apart, and they're having issues with the meet place and point.
Okay, I note that you have in your motion, at least, that they've been meeting in Portland. Is that at a particular exit at a McDonald's?
I'm so sorry. I don't know why I find it so funny. They're in Michigan, but can you just imagine that they are meeting in Portland, Oregon? I'm sorry. Can you imagine that they're meeting in Portland, Oregon? Oh, Lord. Of course they're not. I'm sure there's a place in Michigan called Portland, but I like to believe that somehow they got stuck driving to Portland all the time. Oh, shit.
Gas station.
Gas station, grocery store, yes.
Okay.
And that worked for about a month. And since March, April, we've been having a lot of issues here.
Okay.
Plaintiff fails to show up, is late.
Okay. Mr. Luke, is there any problem with meeting at the location at Portland, that gas station?
Good morning, Your Honor.
Good
Thank you
morning.
for your time this morning. I am requesting an adjournment this morning. I would like to meet with an attorney to discuss my options and establish representation. Thank you.
Okay. Well, Mr. Snyder, typically in these cases, I do allow, if a person wants representation, to at least a slight adjournment. So what I'll do is I'll adjourn the matter to next Monday, same time, 10 o'clock next week. Okay?
Your Honor, Mr. Luke had plenty of time to consult with an attorney.
I understand, but again, I don't want to cut off the opportunity to be represented, so I will adjourn the matter 1 week.
We are asking for attorney's fees and costs, Your Honor.
Okay, we'll address that next week.
Thank you, Your Honor.
Okay, thank you.
Thank you.
Oh, Luke, Dylan.
Thank you.
Oh, Dylan. Dylan, oh, Dylan, with 2 fucking L's. Don't be a loser. Don't be a big bell.
Versus Parr. Both parties are present and attorney pays no. Please unmute. Calling case 2017-3166 DC Luke Spring versus Zung Parr. Today is Monday.
Luke Spring versus Zung Parr. We've had now 2 Lukes, a first and a last name. Also, is he appearing from a diner booth? I'm confused as to how he's appearing today. Also, Attorney Pays No is not my favorite, but not the worst. Also, I heard a rumor that my coverage was pointed out by an attorney at one point to a client. So I'm laughing about that, just wondering exactly how many of them watch. And again, open invitation, because I talk a lot of shit to people. You can anybody can come on. Any verified person that we ever seen on here can come on if they'd like. It just makes me laugh a little bit. I always forget, because we have a small intimate group here, which I love. But, you know, not everybody talks. There could be somebody here that is lurking completely. And then also there's lots of people that watch later. So again, and that don't comment. And it would be really helpful if you commented, guys. I know there's hundreds of you sometimes that watch later. Could you please comment? Uh-oh, Max here. There goes the neighborhood. No, not that bad. Love it. Thank you so much. So much. Let's keep going. Let's see how these, what are they fighting about? Is it a kid or money? Probably a kid.
September 30th, 2024 at 10:02 a.m.
Court will note the appearance of Ms. Paisno on behalf of the defendant. This matter is before the court upon the defendant's motion for appointment of reintegration therapist. Again, previously the court had ordered that the parties would go to the Avalon Behavioral Health, and it's now my understanding, based on the motion, that they do not do reintegration counseling. Is that correct, Ms. Paisno?
It is correct, Your Honor. I had a conversation with that office staff trying to set something up after my client was having some trouble getting records and setting an appointment, and they advised me that they do not do that type of therapy, and nobody in their office would be willing to help in that situation.
Do you have a recommendation, Ms. Paisno, as to who, or do you have to find?
Your Honor, there was actually 3 people I was going to give to the court. One is Margaret Hunter. I know the parties had used her in the past, but it didn't get very far. Rebecca Walker, who is at Kalamazoo Psychology, does reintegration counseling. And then there's a Kimberly Wisdomdorf Houghton Keeper out of the Hastings Battle Creek area. That's my understanding that she is able to do that as well.
Wisdendorf Poughton Creeper? And I thought I had an unfortunate last name, because I have a double-barreled last name, like name hyphen name. But and I try so hard not to dox myself. But that's even worse than mine. Paisley, name. What was it? I want her to say it again. Say it again, Leslie. Say it again.
And then there's a Kimberly Wisdomdorf Houghton Keeper out of the Hastings Battle Creek area. That's my understanding that she is able to do that as well. So I would ask the court order one of those three people.
Okay. Mr. Spring, do you have a problem with either of those three doing the reintegration?
Yes, Your Honor. I can't afford counseling right now, so this isn't going to be covered by insurance. So there was an order previously that Ms. Parr would pay 100% of the bill, but she never did. So I was settled with the debt. I simply can't afford another bill right now.
Okay. Ms. Paisno, is that accurate that she was supposed to pay for this?
Your Honor, I am not aware that she was supposed to pay for the counseling for the children. This court, when we entered the reintegration order, didn't specify who was required to pay. I'm not aware of an order previously, but it could have been before I was involved.
There could be. There's been a lot of orders in this case. So
Correct.
if what the court will do you have a problem with Ms. Walker or Ms. Houghton Keeper, either one of those, Mr. Spring?
Yes, we tried with Hunter.
I didn't say Hunter. I didn't mention her.
Oh, I'm sorry.
I mentioned Ms. Walker, Ms. Houghton Keeper.
I don't have a problem if it's Ms. Parr and one of the children or two of the children, but a lot of the counselors do not like to do that.
Again, that they're saying they saying they would do reintegration counseling, and so if they say that, we'll take them at their word. Do you have a preference, Ms. Paisno? Ms. Walker apparently is closer. I mean, she's in Kalamazoo.
Your Honor, I don't have a preference to either one.
Why don't we try using Ms. Walker, and the court will reserve on the again on the payment of that. I think there may have very well might have a vague recollection that the court had previously ordered Ms. Parr to pay for that counseling. So you might have to go back through the file and find that, but I'm just gonna reserve that at this point because I think there was an order.
You know, actually, Your Honor, there is the defendant shall pay any costs associated with reunification counseling that's not covered by insurance. That's back from June 30th of 2023.
Okay, why don't you just in this order, just so Ms. Walker's well, is to reiterate that in this particular order. I would order that the parties would contact Ms. Walker's office within 30 days of today's date to start that reintegration.
Thank you. Your Honor, and the other part of my motion was, it's my understanding that the minor child, Maria, is not in counseling and only Lucy's in counseling with Avalon Behavioral Health. And I would just ask that she be required to attend counseling for the previous orders as well.
Well, the court will order that. That's no problem. We'll do that and you can conclude that in your order.
All right, I appreciate that. Thank you, Your Honor.
Thank you. You're free to go. Have a good day.
You too. Thank you.
She must have done something to withhold those children for her to be ordered to pay the full cost of reintegration therapy. Allegedly, in my opinion. Allegedly, in my opinion, that is all that I say. Yeah, what is everybody
Next
having?
case
So
is
Thanksgiving
Hopkins
dinner.
versus Frederick.
Thanksgiving dinner around here is very similar to Thanksgiving dinner in the Americas. I know that because I've seen so many US TV shows. But they also serve turkey and stuffing and but one thing we don't serve, green bean casserole, I've heard about. I've never had that. A sweet potato or yam dish would be yes. A turkey would often be there. Ham sometimes. It's very, very similar. Stuffing's my favorite, and gravy and mashed potatoes. And my family would probably serve Yorkshire puddings, which are like little buns, almost like little puffed up pastry. I mean, look, Google them, okay? Just Google them. What else? Because we're Scottish, Nana would often prepare very overboiled vegetables. But I've since learned that is not a part of everybody's Thanksgiving. And then, yeah. At my house, when I was growing up, my mom would make the turkey a day in advance and already prepared turkey soup from it. And it would be like sliced and prepared ahead of time. But not always. Like, not every year. Oh, cranberry sauce comes from the can, though. Sherry, we are in Canada, and Canada has Thanksgiving this weekend. So, it's different in Canada than it is in America. And we are celebrating Thanksgiving this weekend. In fact, that's why I didn't break it to you earlier, but I'm breaking it to you now. We're going to watch this whole court thing, but we're not going to do members only today. We're going to do it tomorrow. Just because I have Thanksgiving matters to attend to that I forgot about. And because it's a holiday. Yeah. You guys get to revel in our Canadian holidays a little bit this way. Yes, Bill, we do. We call them Native, or what do we call them? First Nations. Whose land and territory, unceded territory, I live and work and play. That's actually like a quote from something that a lot of government agencies and workplaces will do before a meeting. They'll do a territorial acknowledgement here, where they acknowledge the First Nations that came before us, and whose unceded territory we reside on and work on. That's pretty common to hear here around here. All right, let's continue.
Sorry, Alicia, I did not mean to bring you in. I'll put you back in the waiting room.
Get the fuck out, Alicia. We don't like you.
Megan, please unmute.
Mhm.
Megan,
Hello?
can you hear me?
Yeah,
Please unmute. Mr.
hello?
Hopkins.
Hello.
Are you Warren Hopkins?
Yes.
Calling case 2019-934 DC Warren Hopkins versus Megan Frederick. Today is Monday, September 30th, 2024 at 10:08 a.m.
Court will note the appearance of Ms. McKenzie on behalf of the plaintiff, the defendant appearing in pro per. There are two motions, motion for order for Family Children's Services to supervise the parenting time, and for plaintiff's motion to dismiss the defendant's motion for custody. Ms. McKenzie.
Thank you, Your Honor. I'm asking the court to regard these motions as unopposed because no answer has been filed.
Well, I'm going to let her respond.
Then I'll go forward. Thank you, Your Honor. With regard to the motion to dismiss the August 1st, 2024 motion regarding custody, the Vadvarka standard was not met. I did attach a copy of Ms. Frederick's August 1st, 2024 form.
The Vadvarka standard in Michigan is the standard that family courts have to reach in order to find a change in circumstances or custody, a significant change. And so there's a layout of what types of changes require meeting the Vadvarka standard. And it's like, it's part of the, you'll hear it referenced quite a bit in Michigan family law. I don't know Cellulite Yoga Pants. I might do a morning show just in here, and I'm not sure what tomorrow holds yet, but we'll see. We will see. But that's what the Vedvarka standard is. So she's saying there was no change in circumstance resulting in their allowing to be a change, because you have to have a significant change in order for them to make a change.
Motion regarding custody. And
Ms. McKenzie, who referred it to the referee for evidentiary hearing? Did the court or was it referee?
I think it was the referee, Your Honor.
Okay, go ahead. When I was reviewing this, I didn't have a recollection of the facts, so I'm thinking my thought, well, I didn't refer it because I didn't recall the facts.
Correct. I just recently got in on the case. There was a long history in this case, but I think that it was the referee after he entered a temporary order in July.
Okay, go ahead.
So, but I don't think that the proper cause or change of circumstance has been shown in the paperwork filed on August 1st, 2024 by Ms. Frederick. She's making allegations, but she did not explain in detail what has happened, and using FOC Form 87 entitled Motion Regarding Custody, it requires in paragraph F, like Frank 5, that a detailed explanation be given. That wording is simply consistent with the requirement of Vadvarka that something spell out what has happened since the entry of the last order to make it, to entitle the defendant mother to another evidentiary hearing. She's filed motions for custody in the past and has failed to appear for her own motion for custody. So the problem is that Vadvarka not being met, and the standard also in 722.271C indicates the authority of the court, as the court is aware. And in 722.27 parent 1C, it indicates that a limitation it gives the court a direction on when the court is able to amend or modify previous judgments. And it indicates that a modification or amendment of a previous judgment or order has to be for proper cause shown or because of change of circumstance. That is the defendant's ticket into another evidentiary hearing. That has not been properly pled. Vadvarka standard has not been met, and we're asking the court to cancel the evidentiary hearing now set in front of the referee for October 9th, 2024. Regarding the defendant's August 1st, 2024 motion, we're asking the court to cancel that, and I will enter an order rescinding that privilege because the Vadvarka standard has not been met. We're also asking for attorney fees and costs, $400 in relation to this single motion.
Okay, well, argue the other motion as well, and then I'll have the defendant respond.
Thank you, Ryan. Your Honor, on July 19th, 2024, an order was entered giving Ms. Frederick supervised parenting time, and the order provided that the supervisor be the plaintiff or the other designee. And because she has made false CSC allegations against my client back in April, naturally and properly, he was unwilling to be the supervisor, but he has sent his designee. Most often it has been his grandmother, Mary Hopkins, Mrs. Mary Hopkins, and she has appeared to supervise the parenting time awarded in the July 19th, 2024 order. But in this particular matter on September 4th, we have multiple allegations of failure of a violation of the parenting time order, the July parenting time order by my client. However, when the time came on September 4th, the defendant mother said that her grandmother was unavailable. She had made arrangements for her own grandmother to go ahead and be the babysitter. And the grandmother mysteriously was unavailable on September 4th. And so Ms. Frederick said, hey, my new boyfriend would be supervisor. So the plaintiff father did allow this only for.
July.
Oh,
Ms. Frederick, don't interrupt. You have a chance to speak
I'm
later.
sorry, my child grabbed the phone.
Go ahead.
only for the reason that the referee had admonished the parties at the last referee hearing that both parties did need to comply with the order, the court's orders. But on September 4th, the defendant mother took videos of the children while she interviewed them, and she was coaxing them to say derogatory things about their father after the children returned home on September 4th. She texted the plaintiff father saying she was going to quote unquote roast him with the videos. So September 7th, parenting time came around, and the plaintiff father sent his grandmother, Mrs. Mary Hopkins, as a supervisor, and Miss Frederick simply refused to allow Grandma Hopkins to be the supervisor. So no parenting time occurred. Defendant mother filed another complaint for denial of parenting time. And she also indicated on that day that on September 11th that she was not going to allow either Mr. Hopkins, plaintiff Warren Hopkins, to supervise. She wasn't going to have any part of Mary Hopkins supervising either. And the fact that she's not accepting the designee of the plaintiff simply indicates that she cannot operate within the parameters of the referee's order. So I'm suggesting that if parenting time is even to continue, the best interest of the children, two young boys, require that a neutral third party be utilized, and that would be Family and Children's Services. And I'm asking that because she is refusing appropriate adult supervisors who are familiar to the children, that she be required to pay, both use and pay for the services of Family and Children's, and that the exchange for the parenting time occur at Family and Children's Services. So I'm asking the court to enter an order requiring the defendant mother to use and pay for Family and Children's Services, requiring the parties to make the exchange of the children ages 4 and 6 at Family and Children's Services, and granting attorney fees and costs of another $400 to Mr. Hopkins. Thank you, Your Honor.
Okay. So you have no problem with Miss Hopkins if she continues. Miss McKenzie?
But if Mary Hopkins continues as
Yeah.
supervisor? Not at all. No, she is an appropriate supervisor, and what is even better is that she's known. She has contact all the time with the little ones.
Okay,
So
thank you.
she is an appropriate supervisor, and she is a sensible individual known to the children.
Okay,
and
thank you.
is my client's relative.
Well, one reason I ask is Family and Children's Services has very limited amount of ability to supervise, and it's very stilted when they do. So
Correct.
with that, Miss Frederick, what's your response?
My response is Mary Hopkins is not appropriate in my eyes. We have family on my side that the children know very well, as much as they know on their dad's side.
Let's just not say she's not acceptable.
Mary.
Tell us why.
Okay, so back in 2021.
Back in 2021, MPC, thank you so much. Happy Thanksgiving. That's so sweet. Something we do here is say what we're thankful for. I'm thankful for all of you guys. I really am. I'm thankful that all of my Florida friends are safe. I'm thankful for us being able to gather together and enjoy this family's crisis. Because I'm a little bit evil, and that's okay.
or back in 2019, sorry, Mary and Warren Hopkins attacked me with my 7-month-old Jaden Hopkins, our child that we have in common, in my hands. Mary bit my hand, trying to get me to drop my child. I made a police report. Still to this day, I have a scar on my hand from her biting my hand. She coaches the kids to say certain things to me. They don't want to talk around me when she's around. She gives them the evil eye. She instigates with me, tries to cause arguments with me. She's just not appropriate. It's just a game. It's just a game. I don't understand why Warren himself can't do it, or one of my designees. My boyfriend, I never said my boyfriend could supervise. I don't have a boyfriend. It was the third party that's a friend. My grandma wasn't able to get up in the truck. She had a doctor's appointment that day. My grandma is able from here on out. It was just that day she had a doctor's appointment, and I didn't know. But as far as Mary Hopkins, I have videos of her coaching the kids and whatever else. So she's done nothing but cause problems, and it's just not a good idea for her to supervise.
Okay, well, anything else, ma'am?
No.
Okay. Well, the court in the prior order did state that the plaintiff could again designate, is my understanding from the referee's order, that either the defendant could supervise or the designee in this matter. Was that the plaintiff's designee or the defendant's designee, Ms. McKenzie?
I'm reading that as Mr. Hopkins designee, Your Honor, because it's all in the same paragraph.
Okay. What the court's going to do, the court will appoint Mary Hopkins as the supervisor in this matter.
Absolutely not.
Well, ma'am, you don't have a choice. I'm ordering it. So you don't comply with it, you could end up in jail if you want to go that route. So it's your choice. It's your choice, ma'am. Court will.
She disconnected from the, I'm not sure if she's no longer on our hearing, in our hearing. Megan Frederick is no longer in the hearing.
Okay. Court will note that it's 10:20 and apparently she's disconnected. The court is going to order that the designee would be Mary Hopkins. Court is not going to, court will note that the fact finder, the referee, had apparently made a preliminary determination that there was a proper cause or change in circumstances. I don't know what the referee was looking at that particular point, but the court's not going to intercede and again, take away the referee's discretion in this matter. It may be at a future point, depending upon the outcome, that the court does have to review it as a result of de novo, but not at this point. So the court will allow the referee evidentiary hearing to proceed in this particular matter. And the court will just simply reserve on cost at this time. And you can prepare the order, Ms. McKenzie.
Thank you, Your Honor.
Thank you.
She won in some cases. She got her hearing about custody. She shouldn't have disconnected. Damn it, Megan. The judge should have listened to her a little bit, though.
Plaintiff or defendant on the Corbin versus Corbin. Do we have someone I'm checking in real quick? I can't identify them.
By his jawline, that's Wesley Todd. You don't know him?
Please unmute. Wes is attempting to connect to audio. I don't think Wes knows. Please unmute Motorola. Please unmute.
Please unmute. Hi, Rainbow.
Please unmute.
Please unmute.
Motorola,
live hours.
you're still muted. You're gonna have to unmute. Bottom left corner of the screen.
She's got a lion above her
What
shoulder.
we'll do, get a pen, and that will give you a phone number to call, and you can join by phone.
KCC points or chips are completely arbitrary.
Okay? Ms. Woodard, would you give her the phone number?
Yes, I'm trying to find.
One day I might get around to switching our system to a roulette system that will work as
Christine, Your
well.
Honor, I don't think this person is for my.
Yep, I'm gonna put her in the waiting room.
Sure.
Calling case 2017-2362 DM Jamie Corbin versus Floyd Corbin Jr. Today is Monday, September 30th, 2024 at 10:24 a.m.
Court will note the appearance of Mr. Todd on behalf of the plaintiff. This is before the court on the plaintiff's re-notice of entry of amended order for custody parenting time. The court will grant the order. As a result, the defendant has not appeared. The defendant has not filed any responsive pleadings, and it is now 10:24 a.m. The matter hadn't been set for 10 o'clock a.m. So the court will enter that order, Mr. Todd.
Great. Thank you, Your Honor.
Thank you.
Have a good one.
day.
Bye, Wesley. See you later.
Now I'm bringing in Attorney Storm.
But you have a female plaintiff that could be the person that's trying to join.
Yes.
So you need to give them the phone number so that
I
they
gave
can.
her the phone number, but she's still on as. Please unmute. Clinton. Please unmute Clinton. Clinton.
Yes.
You see, is this Michelle Watkins by chance?
No.
All right, can you hear me, Motorola?
I can.
hear.
Yes, ma'am.
All right, perfect. What's your first and last name, please?
Mine is Danielle Harrell.
Is it formerly Danielle Clark?
Yes, ma'am.
I'm sorry. Danielle, I'm gonna place you in the waiting room, okay?
Okay.
Thank you.
Deja vu.
All right, hold on here. Oh, I just lost everybody.
That's not funny.
All right, calling case 2011-1204 DS, Michelle Watkins versus Clinton Edwards. Today is Monday, September 30th, 2024 at 10:26 a.m.
Court will note the appearance of Ms. Storm on behalf of the defendant in this matter. The matter is before the court on the defendant's motion for modification of domicile, modification of custody, parenting time support. Ms. Storm.
Thank you, Your Honor. I'm sure the court's already read the motion, so briefly, we have a situation where we are locked in this repeating pattern with mother, where we have instability and inconsistency in the custody issues regarding their minor child, specifically the child's mental health and other medical needs. There was an incident where mom refused to refill a prescription that was necessary for the child. The child then had withdrawals from that, and it got so bad that the child had to be taken to the hospital, and then she was kept an inpatient for a number of days. This is a pattern by mother where things, as soon as things fall apart, she's back on, promises are made, I'm going to change. And while the eyes are on her, like with a CPS investigation, she's great. But once the investigation or the eyes are off of her, she lapses back into instability and inconsistency. And this is having a negative impact on the party's child. She has asked to live with her father. She knows that being with dad is going to be a more stable place for her. My client has the ability to have the child live with him. He's been in a stable home for quite some time now and is more than willing and able to ensure that the child's medical and educational needs are being met. So we would ask that the court consider our motion and likely set it for an evidentiary hearing.
Okay. Well, we don't have the plaintiff. Do you know at all why the plaintiff isn't here, Ms. Storm?
She had indicated to my client that she kept indicating that she didn't have notice for today's hearing, even though she had received all of the notices that I had sent prior, as I had some scheduling difficulties. And so having sent this in advance, she even confirmed via text with my client that she knew the hearing was for today. I'm not sure why she's not here or not participating in today's motion hearing.
Okay, well, the court isn't either. I just didn't know if you knew, and it is now 10:29 a.m. It was set for 10 o'clock. I will allow you to proceed with an evidentiary hearing before the referee in this particular matter. I would state, based upon my reading of the motion, however, that it's very a weak motion at this particular point, but there is enough there to proceed with the evidentiary hearing, and hoping that the plaintiff would respond and give us some indication, but she hasn't. So allow you to proceed, and we'll refer it to the referee.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Weak
Can someone
motion. The
join?
motion
I'm
is
going
weak.
to check
Storm.
them in to identify. Good morning. Your first and last name, please.
Paisley, none of your business.
April Keeler.
April Keeler. Okay, I do have Daniel Miller. So let me bring Daniel in. Daniel, please unmute. Calling case 2015-1835 DC, April Keeler versus Daniel Miller. Today is Monday, September 30th, 2024 at 10:30 a.m.
Court will note that this matter is before the court on the defendant's motion to modify custody, parenting time, and support. Mr. Miller,
Yes, sir.
go ahead.
Hey, is April joining us?
She is.
Okay. Your Honor, on June 10th, you awarded the plaintiff, and we agreed to let her have supervised visits with our minor child, Keon Miller. Since that time, Ms. Keeler has participated in one visit and has not done any Wednesday visits. She has not reached out. I haven't got any phone calls to try to get set up a time or to pick up or anything like that. So she's refusing. Sorry. She's refused basically to participate in these visits. She has also, since the last court hearing, looks like she has 2 driving while license suspended and 1 open case of driving under the influence. Because Ms. Keeler has not participated in any visits and doesn't look to appear to be going to any time in the near future, that with her continued alcohol use and drinking and driving, we just don't feel it's necessary to have on record that she should have any kind of supervised visits or otherwise. Therefore, we'd ask that you remove those supervised visits from the order.
Okay, how does the fact, and I can't say that if she's obviously incurred some additional DUIs, that won't have an impact, but if she has a supervisor, how does that impact the visits if there is in fact a supervisor?
Well, she's not participating at all. She hasn't reached out to participate. She hasn't tried to.
Well, if she doesn't participate, then she forfeits the parenting time. So that's her option, I guess, at that point.
Yes, and we'd like to to have that on record, that the order be changed. I mean, I don't want him looking over, questioning, oh, is today going to be the day she tries to come in? Because, at this point, he doesn't want anything to do with her. I mean, she hasn't shown any effort. She's not trying to show any effort to be in his life, or at this point, I just feel she's a danger,
Okay.
to his well-being.
Ms. Keeler, what's your response?
That's not true, Your Honor. I have reached out to my son. I don't reach out to the father at all. I have reached out to my son. I have seen him. I have talked to him. I have texted him. So that is not the case. And all the other drive-in while licenses are suspended, they've been thrown out. So all of that is irrelevant. And like you said, it is supervised. And every other weekend, a teenager does not want to sit at his grandparents' house all weekend. So there is complications with that sometimes. There's also been football camp during my time where I'd allowed him to go to camp instead of coming and spend time with me. So there are reasons why I am missing some of my time, but it's not because I want to miss out on my time with my son, Your Honor, at all.
Okay. Well, the court had previously ordered supervised parenting time. Again, I don't know what the particular issues the defendant has brought up, but brought up some issues in that matter, but that would not impact supervised parenting time, as that there would be a proper supervisor. What the court will do in this matter is I'm going to deny the motion. There's not a basis to eliminate the supervised parenting time. Only thing I would do is order Ms. Keeler that when you do have the parenting time arranged, if you do talk to the child and arrange it, that you confirm that with the defendant so that he knows what's happening in this matter, because you need to have that communication so that you would confirm with him when the parenting time is going to occur, and obviously that you'd have the supervisor present for those particular visits. And Mr. Miller, I'll let you do a order that simply states that that she would communicate to you when that parenting time is going to occur.
Sounds good, Your Honor.
And you can submit that under what they call a 7-day notice of entry. If there are no objections, then the order would be entered. So, okay?
Yep, thank you.
Thank you. You're free to go. Have a good day.
You too, thanks.
Thank you, sir.
Case is Clark versus Shelley. We have plaintiff, defendant, and attorney Robinson present.
It's long and annoying. I almost cut it yesterday.
Please unmute. Reginald, can you hear me?
My sister
Calling
says
case
it's, hold
2012.
on. My sister says my hair is so healthy because I never do anything to it. She's like, you don't blow dry it? I'm like, no. She's like, you don't straighten it? No. You don't curl it? No. You don't use product in it? No. So evidently that's very good for your hair. And so for that reason, my hair is quite healthy. But I also haven't dyed my hair in a year. I'm trying to grow it out so that I don't have to pay for a color correction. I can just get an actual... I want to go blonde. I want to go blonde, but I don't want to pay $500 for it, so I will grow it out.
3371 DP Danielle Clark versus Reginald Shelley. Today is Monday, September 30th, 2024 at 10:36 a.m.
Court will note the appearance of Mr. Robinson on behalf of the plaintiff. This matter is before the court on the plaintiff's motion to change custody. Mr. Robinson.
Thank you, Your Honor. I think our pleadings pretty much set forth our reasons for the necessity of an order changing custody. Mr. Shelley hasn't had any contact with his son in over a year as the result of severe beating he gave his child. The son is absolutely terrified of his father. He doesn't want to talk to his father, doesn't want to see his father, doesn't want to be with his father, who was supposed to be on probation for another 8-9 months, but they terminated his probation early without notice to my client or to the boy. And what I'm asking the court to do is set this matter for a brief evidentiary hearing, perhaps parties only, so that we can get an order keeping him in place with his mother.
Okay, thank you. Mr. Shelley, you're muted. You'll have to unmute, and then what's your response?
Shelly, what's your response? John, unfortunately, a lesson that I've learned before is that if you have professional dye in your hair, which I do basically from like here down, because my sister is a hairdresser and she used to buy me the dye and she taught me how to mix it. And so I would dye my hair with like salon quality stuff. I'm just not a fool. Like, the reality is it's an expensive and serious process to get rid of all the color, correct it back. Basically, I want to go the opposite. I want to go from dark hair all the way to blonde. And that you have to go through every color in between first before you can get to the blonde. And so, but I have lots of gray hair coming in at the top, and eventually I'll just be able to cut off all this hair and then you can just dye it blonde. You don't have to color correct it. But down here, you'd have to strip out all of the existing salon color. And I've dyed my hair before when I had salon hair, and then I dyed it with a box, and it turned orange and terrible, and it was a bad situation. My sister's a hairdresser, 2 of them, in fact. But the reality is it's still an expensive and extensive process. It would probably take like 8 hours for this long a hair. Ideally, I want to grow my hair out till it's like shoulder length, cut off all this, and out we go. And super stickers, yeah, I get most of the money, Sallyport. YouTube Daddy takes his 30%, but other than that, yeah. And yeah, so that's where we're at. So even though my Nana saw my hair and she like gasped, she's like, "You've got gray hair, white hair." I'm like, "I know, Nana, but it's for a means to an end." Anyways, this case sounds horrific. Don't beat your children. I don't know why I have to say that.
Mr. Shelley, you're muted, so we will need you to unmute.
Please unmute.
You have to unmute, sir. Bottom left corner of your screen, hit the microphone. It'll allow you to unmute.
Sally, that's the best! Why isn't Streamlabs putting it up? I'll put it up myself. Thank you, Sallyport. That's so sweet. Streamlabs, we're gonna need to talk later. Come to my office later. And Sally, thank you for being you. And your support always. Seriously, means a lot. And thank you guys for being with me on Thanksgiving. You're my family. My chosen family, as I like to say. This guy, again, just don't beat your children. I don't know why it's behind. Streamlabs and I need to have a little talk. A little talk. A little talk.
We still can't hear you, sir. You're still muted.
That's what it's all about. Oh, get a younger person to help you with a hat on. Perfect. The trifecta in court.
Please unmute.
Please unmute. Please unmute.
Click
I
on
hear
the
that in my dreams.
microphone.
I only hear in my dreams, by the way. I don't
If you
see
scroll down
anything.
to the bottom of your screen, there'll be a microphone that'll come up that says audio on it. And if you hit that, then you're going to unmute yourself.
Poor choice of words, Judge, when he's accused of beating his child. But yes, hit that button. Hit
If you
that
can't
button.
do that, then maybe you need to get off and then rejoin, and then maybe that will eliminate the problem.
I'm always laughing at the couples. Like, how did they meet? Why don't we ever get to talk about that? How did you meet Reginald, Danielle? What are you drinking, Danielle? A large American drink. So jealous of your big pops.
I've sent him messages and he's not replying to the messages.
Still cannot hear. You're still muted, sir.
Send him the phone number to call in.
Send me your number, I'll call it all the time. You'll wish that you hadn't said you would be mine. Yeah, no, that wasn't a large even. That was a medium. Probably good to show up in court, but you know what, Tony? This judge didn't even show up in court today. He's virtually appearing just like me. Also, doesn't that look like Snoop Dogg?
Fortunately, I think I'll place you guys in the waiting room and then I will bring you in after.
Give them a few more moments and then we'll go ahead.
I'll try to check someone else in maybe.
Yes, go ahead.
And I'll try and check someone else in. Maybe. They need like 3 waiting rooms.
Please unmute.
Okay, you're going to have to disconnect from the computer because we're getting feedback, and then you can appear.
Can you hear me now, Your Honor?
Yes, we can.
Okay, we're gonna kill this.
But we may be only hearing you through the phone. I don't know if we can hear you through the computer.
Disconnected.
Nope. We can't hear you now, sir.
I
What you're
think
gonna have to do is,
disconnected.
yep, join by phone and then shut off your computer. We could hear you on the phone, but we can't hear you through your computer.
They're both phones, Judge.
Join by phone, sir.
I sent him the phone number.
Hello?
Hello, Kelsey.
Yeah?
All right, so it'll be just a few minutes, okay? I'm gonna put you in the waiting room.
Yeah.
Thank you.
Yeah. 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 I know I can be annoying on the phone too.
I have rejoined.
Mr. Shelley, join by phone, please. You're not getting through on the computer. And once you join by phone, then disconnect the computer.
Oh, Lord be.
Right. I'm going to put you in the waiting room. We'll call another case and then we'll bring you guys back in, okay?
Okay.
Okay.
Who said that?
All right, this is going to be Kelsey and Edward Daniel.
And unmute it now. Ah, it's cold.
Yay! Sally Port, thank you so much. Oh my God, 10 new members. That's amazing. Thank you so much. Also, Kelsey is chewing up a storm. What is she eating? She's in her car. I think it's safe to say she is eating something from a to-go restaurant. Would you say that? You are so sweet. Oh, that is so sweet. As a reminder, we'll be doing a members only tomorrow. Plus, because it's Thanksgiving weekend in Canada, it's shifted to Monday. And I found a video of me from 10 years ago that I'm going to share. I have to figure out how to get it up on the computer. It looks like it was filmed on a Nokia fucking flip phone, but it wasn't, I swear. Anyways, thank you so much, Sally Port. Let's see if Kelsey manages to close her mouth at all during this hearing.
Miss Daniel, do we need to wait until you're done eating?
No, I'm good. I can wait.
Well, we can't, so you'll have to.
Yeah, no, I'll wait to eat.
Okay.
Calling case 2024-645 DM Kelsey Daniel versus Edward Daniel. Today is Monday, September 30th, 2024 at 10:44 a.m.
This matter is before the court on the plaintiff's motion requesting additional time to present evidence. Why, Miss Daniel, do you need more time and did not produce the evidence when you had your hearing?
I didn't receive anything in the mail to show me that I only had 21 days. Normally they told me I had to do a change of address for me to get mail. So I'm like, okay, so I did that. And then I was like, okay, now I can bring the evidence. It's like, no, you have to sign a motion or ask for more time. I was like, oh, okay.
This is a referee hearing, isn't it?
This is to bring evidence to the trial.
Okay, hold on.
Yeah.
Miss Woodard, is this set for the referee?
No, this is a trial. It's a DM trial. There was a case scheduling order entered on May 29th. Discovery until July 1st, mediation in July with a settlement conference in August.
Okay. Well, Miss Daniel, you've missed the deadlines by a long shot. This isn't close. So the case schedule order was from May 29th. It told you in that case schedule order that you had the 21 days from the date of the first mediation that occurred in July, and you haven't complied. You're now well over 2 months past the deadline. You could have filed any time in May from May on. So why should the court give you more time when you haven't basically done anything in 4 months?
Because like I said, I didn't get the notice in the mail. So that's why if I would have got it, you would already had the evidence. Because I have everything right now.
Okay, let me ask Mr. Daniel. Mr. Daniel, do you oppose more time to provide evidence in this matter?
I oppose.
Okay.
It's done.
Okay. Well, what I'm going to do is, again, those orders are again put in place. And at the time that we had the scheduling conference, we informed you that there would be dates that you had to comply with in the order. And we stated at that time, if you didn't comply with those, it would have, could have consequences to your case. And you haven't complied, and you would have gotten that again. You would have got that order sometime in early June. And now we're ordering on October. So the court is going to deny your motion for additional time. You can testify yourself in this particular matter, but as it relates to anything else that you should have produced, the court is going to deny that at this point. So that will be the order of the court. Mr. Daniel, you'll have to do an order denying her motion for additional time to present evidence.
Yes, sir.
Okay? Thank you. You're free to go. Have a good day.
You too.
She didn't think that was going to be as hard as it was, I don't think.
Good morning, can you hear me?
Pardon me?
Are you Reginald?
I can't hear that. Hello?
Hello, your first and last name, please?
This is Reginald Shelley.
Okay, perfect. Calling case 2012 3371 DP Danielle Clark versus Reginald Shelley. Today is Monday, September 30th, 2024 at 10:49 a.m.
Okay, court again will note the appearance of Mr. Robinson and the motion to change custody. Mr. Robinson, I hate to have you have to go through it again, but if you would just reiterate what you said previously.
Thank you, Your Honor. Our petition sets forth the material facts and the reasons why we believe it's in the child's best interest that custody be changed to his mother. Mr. Shelley was convicted of a fairly serious assault on his son last December, was placed on probation for a year and a half. His probation was terminated 9 months earlier. He now wants back in the child's life, but the child is terrified of him. He doesn't want to talk to his father, doesn't want to see his father, certainly doesn't want to be with his father. And what we're asking for is a brief evidentiary hearing, perhaps with the parties only testifying, in order to establish the facts necessary to change the existing custody order.
Okay, thank you. Mr. Shelley, what's your response?
My response is I was wanting to try to get a termination adjournment till I can give me a counsel.
Okay,
I need a counsel at this point.
Okay. What we'll do is, again, I'll let Mr. Shelley have an opportunity to have attorney present. What we'll do is we'll adjourn the matter 1 week. So Mr. Shelley will come back in next week at the same time. So you'll need to have an attorney present at that time, okay?
Okay, a week from today?
Week from today, correct.
I don't really, I was at the point, I don't really want the son to be in her custody either. She's not supposed to have him.
Again, if I'm not going to let them argue stuff, I'm not going to let you argue it. I'm adjourning it 1 week, 1 week till you get an attorney.
All right, thank you.
Okay, thank you.
Well, that was depressing as fuck. I'll try and find the follow-up on that, y'all. Maybe we'll watch that tomorrow morning. Thank you so much for being here today, for celebrating Canadian Thanksgiving with me. Thank you again, Sally Port, and everybody for your generous donations today, and for your time. That's the most precious thing we have of all. And I appreciate that you spend some of yours with me. Once again, we will be back tomorrow. I'm on the mend. I'm getting better. I'm even less medicated today. So we are getting to it. Tomorrow's Columbus Day, but I will be here. We do not have Canadian goose instead of turkey, Bill. I probably will have a vegetarian mock-up of a Thanksgiving dinner today. we'll see. We'll see. Members only will be tomorrow, Cellulite Yoga Pants. Yeah. So at least 2 shows tomorrow. But thank you guys so much for being here. Remember that I love you. I'm proud of you. And I will see you in the next video. Bye.
Ways down red.